This is Michael Popok, so it must be legal AF after dark. Everything's done with the Supreme Court for this term, except for sending out all their orders and dropping all of their decisions related to the prior briefing and oral arguments in cases that matter to America. We're waiting patiently for a number of them, but first, we had to pick our way through and do the analysis related to the 8-1 decision, which on its face looks like it is in favor of civil liberties and a curtailment of gun rights in America just 2 years after the big case written by Clarence Thomas of Bruin versus New York Rifle. Now there's a new declaration about how to use historical precedent. This is the Supreme Court now. How to use historical precedent when you're looking at gun control or other types of regulation, particularly a person who has committed domestic violence and is the subject of a temporary restraining order or an injunction. Do they get to keep their guns under the Second Amendment? Clarence Thomas think that kind of person should. Somebody who beat up his partner, victimized her, went on a shooting spree. That person should have a Second Amendment right, so says Clarence Thomas. What did the other Supreme Court justices say about that? Well, we tell you and analyze it for you on Legal AF. Take a listen.
Michael Popok, ready to talk about the United States Supreme Court rulings. A lot to talk about, both in terms of what they ruled on and what they didn't rule on. I guess let's just start with what they did rule on. An 8-1 decision, United States versus Rahimi. The U.S. Supreme Court allows for there to be federal gun restrictions for domestic violence suspects, and it was an 8-1 decision. So in theory, you can go, wow, the eight Supreme Court justices agreed on something. But I think there's a little more than meets the eye here, because remember, the prior week, the Supreme Court had ruled not based on Second Amendment jurisprudence, but based on trying to destroy the ability of agencies to implement common sense regulations, that bump stocks do not constitute machine guns, and allowed bump stocks to be freely sold. So that was the decision 2 weeks ago. So then, Popok, as you said, they will issue a decision like that they know will rile up the American public, rightfully so, and piss everybody off. And then they take a case like this where it's like, it's really even a question that people are saying those who are under domestic violence restraining orders should have access to guns. And they'll be like, no, you can't have guns. We agree with that at least. And then they want to take credit for the most basic and obvious of things. Surely domestic abusers shouldn't have guns. Although the dissent, Justice Clarence Thomas, said, hey, everybody, remember that decision? The New York Rifle Association versus Bruin in 2022, that all of you right-wing justices agreed with me. If we really meant what we said in Bruin, and we're going to apply a historical tradition test, then if we go back in history, women were always abused by their husbands all the time. And there was no issues about domestic abuse in the 1700s. So therefore, how could we even acknowledge that this is what Justice Clarence Thomas is arguing, right, Popok? It's horrific. How could we even argue that domestic abuse is even a crime for purposes of Second Amendment jurisprudence? Domestic abusers could have guns if they wanted to back in the 1700s. Surely they could have guns now. And that's what we ruled in Bruin, everybody. That's the precedent right now. And the other 8 justices were like, nah, we're not going that far, Justice Thomas, but we'll apply your historical tradition test in Bruin however we want in future cases. Just on this one, we're not going to go that far as it relates to domestic abuse. Popok, what'd you think about that ruling, huh?
Wow. Yeah. And look, so this is what the ruling reflects. And the harbinger for the ruling, what I call the canary in the coal mine, is that a week before, obviously knowing that there was these opinions circulating, like the Clarence Thomas out on an island of his own, where he's left Rahimi, who in the main decision written and penned by Chief Justice Roberts, he spent a considerable amount of time and spilt a considerable amount of ink giving how depraved Rahimi was in abusing his girlfriend, physically abusing his girlfriend, and going on a shooting spree while he was the subject of a federal injunction against him having a domestic violence, and against him having a weapon. And what I said, and so you got this mismatch of Clarence Thomas, the lone justice, who's defending the right of a guy who punched and beat up his girlfriend in a parking lot. This is from the decision. Who then went on who attacked her in her home despite the injunction, the restraining order, who then went on a shooting spree where everywhere he went, a fast food restaurant, a road rage incident, he pulled out his gun like he was in some sort of weird wild, wild west moment and started shooting it off into the air or at people. And so when you see, and this is like the secret decoder ring for the Supreme Court, when you see a description of the actual facts in a case, as opposed to what the MAGA Supreme Court usually does, which is says, let's not get bogged down with the facts. When you hear we don't want to get bogged down with the facts, that means they're about to make, in a judicial activist moment, new law, which they're not supposed to do without reference to the record below. When you hear them, on the other hand, recite the facts, that's because they're having trouble with somebody on the court like Clarence Thomas, and they want to, as they're circulating their drafts, they want to say, really? You're going to defend this guy? The guy who's the drug dealer, gun shooting, gun spree, woman abuser? That's who you're defending? And so when you see that, I was not surprised to see John Roberts speak at length about the actual facts in the case, because they don't really matter to what they're about to decide. It was done for a reason. And the harbinger, as I started to say, of this decision is Amy Coney Barrett in an unrelated decision 2 weeks ago that you and I talked about, and I did a hot take about, which is the copyright decision about whether a lawyer, a person, could get the copyright on Trump is small after his debate with Marco Rubio back in 2016. And could he actually register that with the Copyright Office? And Clarence Thomas and the others once again said, we go to a history and tradition test. We go back and try to find an exact identical duplicate law that was on the books during the First Amendment period to decide whether we're going to allow this or not. And even Amy Coney Barrett called that out and said, enough with the history and tradition test. It has its limits. First of all, why are we, to paraphrase Justice Roberts in the most recent decision, why are we trapping the law in amber? Why are we making it where we have to go find an exact identical historical twin in order for us to provide the lower courts with a test? We're supposed to give them a test. We're the Supreme Court. This is Amy Coney Barrett. How are they supposed to do their job? And what are you going to do when you hit the point when there is no history or tradition around a certain regulation? How do we regulate nuclear power plants? What would the founding fathers have done? Well, they didn't have nuclear power. I mean, that's where you're at. She said, just do a judge-made test. So that's what we're supposed to do, not history and tradition. So when you see on the special decoder ring edition of Legal AF, when you hear the words history and tradition by Gorsuch, by Kavanaugh, by Alito, by Thomas, now what they want to do is remove the regulation and the restriction, and they're going to do it by referencing the vast historical tradition of our country. Even John Roberts and the other 7 on the Supreme Court said that Clarence Thomas, as a Second Amendment absolutist, is off the chain, is an outlier. We can't even go that far. And what they did is, and I took him to task on a hot take on this, John Roberts elided over. He conflated in order to act like it wasn't us that was at fault with our Bruin decision 2 years ago, even though Clarence Thomas wrote it. It was the way the trial courts are interpreting it. Now, Ketanji Brown Jackson, in her concurrence, said, no, it's our fault. We didn't give them the proper guidance. We said, go and find an historical twin. If you can't find an identical law about gun control in 1791 or the 1800s, despite the fact that contextually, looking for a law unmoored from the historical context of how women were treated in the 1790s and 1800s, or even now, how Black Americans, now Americans, were treated, is unhinged, to put it mildly. A woman, let's just take domestic violence and the Rahimi case. There was no crimes against domestic violence during that old-timey period because women were considered owned as chattel by their husbands. they didn't have the right to vote. Some people noted it in the back. In honor of my upcoming daughter, I found this amazing thing from the suffrage movement. Women bring all voters into the world. Let women vote. We had to have signs and posters like this in this country because the women didn't have the right to vote. So you can't go, well, you could have freely abused your wife back then, so you're allowed to have a gun now. That is where Clarence Thomas has gone. It's not a slippery slope. It's where he's gone. And so Chief Justice Roberts said, well, we need to sort of walk this back a bit. You don't have to look for an exact twin in the law. You just have to find a law that is part of our history and tradition that undergirds the law. And since there's a history and tradition about taking guns away from bad people who will harm people in public, we'll find that this law about domestic violence should disarm people like Rahimi temporarily. I don't want to oversell Rahimi. It is clear that under Rahimi, that when Rahimi rehabilitates himself and is no longer a threat to society as adjudged by a judge, he's going to get his weapons back under the Second Amendment. As I said recently, the amendments that came from the original Constitution after the framers of the Constitution said, now that we got the living, breathing document of the Constitution done, we better go back and make some changes and make some additions. First 10 amendments, the Bill of Rights. They are not ordinal. They are not ranked. It is not like the First Amendment is above the Second Amendment, nor is the Second Amendment above all other amendments, including the First Amendment. They are 10 amendments. But the way that the Supreme Court in MAGA has supercharged and turbocharged the Second Amendment and made it so robust, it knocks over all the other amendments. You know, they're so focused and fixated on the right to bear arms, now an individual personal right outside the home after the Bruin decision. Now they see what it wrought at the trial level, right? Now they see the trial judges struggling. They're making trial judges historians to have to go back with their law clerks to go back and do a search as opposed to just giving them a standard test. So that's why it looked like 8-1, but you had about 5 concurrences that were written, 1 dissent that was written, and everybody joining in on the majority opinion except for Clarence Thomas and the left wing or the sensible wing of the Supreme Court. Sotomayor, led by Sotomayor, applauding at least the rollback of Clarence Thomas' ridiculous absolutist Second Amendment position that put him in a position, Ben, to defend a violent domestic abuser who went on a crime spree and is a drug dealer.
Well, you know how we always say everything with this MAGA Republican Party is projection or confession. It's really the same with the Federalist Society movement. They went around for decades calling the liberal judges activists and that they're coming up with law as it goes, when in fact the so-called liberal judges were actually applying the law and applying the precedent, and also in a common sense way recognizing the issues that exist in the current modern world that we inhabit today. But what the Federalist Society did is they would create these labels to make it seem like they were smart and that they were intellectuals, but in fact, they're really sociopaths who just try to come up with a framework. So it's heads, I win, tails, you lose, no matter what the outcome is, right? So they're states' rights until they want and are okay with a federal abortion ban. They are strict textualist or strict constructionist until you read what the Second Amendment actually says. And it says a well-regulated militia. It uses the word regulation and it talks about a militia. A well-regulated militia being necessary to the security of a free state, the right of the people to keep and bear arms shall not be infringed. So then they go, oh, I guess we can't actually be strict textualists there, because if we read the text, it's the only amendment that actually uses the word regulation. And our whole point is that there shouldn't be regulation. So, let's come up with another test and call it the history and traditions test. And whose history and traditions? The same people who say, make America great again. Whatever that means to you, we're going to find our own version of history that suits us, and we're going to come up with an outcome based on how we read history, not even what really happened in history. Because if you go back to, there weren't AR-15s. I mean, there weren't guns and machine guns or anything close to what guns look like today. So if you were really going to do a history and traditions test, anything but like muskets, right, or whatever should be all banned to begin with. But no, we're going to do our history and tradition test, and we're going to apply that. But that to me was one of the biggest revelations, because when I'm in law school, when you're in law school, they teach you doctrines about being a strict textualist and a strict constructionist and states' rights and the words conservatism and precedent and super precedent. But then you learn as you evolve from law student to law practitioner to kind of this observer of the hustle. And you go, wait a minute, y'all just made all of this stuff up in order to justify the outcomes that you wanted. You're not textualists. You're not even true history and tradition. You're not states' rights. You're not even conservative unless you want to conserve the monarchy. And I think we see that on full display here. You certainly don't want to conserve our democracy. And how do we know you don't want to conserve our democracy? Because you haven't even ruled on the absolute immunity decision. You haven't ruled on it. You have not ruled on a critical decision. So no matter what they rule, they've already granted a form of de facto immunity to Donald Trump from being held accountable for leading an insurrection against our country by not taking the case on an expedited basis when Jack Smith requested it in December. Then when Donald Trump requested a stay later in February, they convert that into certiorari and then accept it for oral arguments and then delay the thing where here we are, June 22nd, and there's no ruling. They've already given him a de facto immunity. They've already given him the power that no one has in this country. They've given him the power of kings because they've blocked a trial arbitrarily, capriciously, recklessly, maliciously.
Welcome back. That was Legal AF. It's a full-length podcast we do on Wednesdays and Saturdays at 8 p.m. Eastern Time right here on the MeidasTouch Network. It's a free subscription network. Yes, you never hear those words. Free subscription network. No paywall. You come right in and you can follow every show and every content on the MeidasTouch Network. We're building this network with our bare hands with your help. No outside investors. The way to support us is to free subscribe and come on and become a part of our audience on shows like Legal AF. If you know all about Legal AF, I wanted to thank you right here from Michael Popok to you for being part of our audience. We couldn't do it without you. You know, we give it to you straight. No, nobody censors us. Nobody censors our content. We're unplugged. Sometimes we're unhinged. We're right here on the MeidasTouch Network. If you know all about us, take that clip, that little bite-sized moment in Legal AF history, and send it off to friends and family, other people, and ask them to join our audience. And if you don't know about Legal AF, I'm going to invite you to join our audience right here. So until my next hot take, until my next Legal AF, this is Michael Popok reporting. Heary, heary, Legal AF Law Breakdown is now in session. Go beyond the headlines and get a deep dive into the important legal concepts you need to know, and we discuss every day on Legal AF. Exclusive content you won't find anywhere else, all for the price of a couple of cups of coffee. Join us at patreon.com/legalaf. That's patreon.com/legalaf.